Legal, which is similar in jurisdiction to Maine Human Rights. We're kind of the gateway for all those questions. So we provide the person when they call, they get the call is answered by a live person. If it's an employer, we give them the employer information in direction, in the contacts, for them to know in terms of following labor law. And if it's a worker, we give them the contact on the worker side for investigatory or complaint purposes so that they would follow up there. So, and actually, as the executive director stepped out, Director McGathlin and I gave her our cards so we can continue to do more joint public awareness of those issues.
Sure. On your website, do you have a standard application available that somebody could look at that would be clear about the kinds of questions?
No, because again, that's not under our jurisdiction. There may be more. I'd have to look in the employment rights one from, or the new employment guides on the Maine Human Rights page as to whether or not they have a sample application. Different jobs have, different employers have slightly different ones. On the job bank, we do not include any of those, and we scan the employer's information when they're submitting the job to make sure there's no discriminatory language in any of the jobs that are posted on the main job bank, which is the one thing that we do have jurisdiction over through the Bureau of Employment Services. And if any employer wants to participate in our job fairs or recruit through the career centers, they also have to get a check to make sure they're not doing any discriminatory practices, which include things like long-term unemployed as well as criminal history and things like that.
Representative Gilbert?
Thank you, Madam Chair. I have a news article from Bangor Daily News that refers to a large company in the Worcester Auburn area. And I think that company recruits through the Career Center. And this says that, I'll paraphrase a little bit here, it says, like this Oscar County man likely suffered age discrimination when an Auburn company required him to share his high school graduation date as part of the application for employment. The Human Rights Commission decided this way. My question is, and I'm pretty sure this company still recruits through the Career Center, uses its own applications. I'm just wondering how an application like that, if it's still the case, was used at the Career Center.
I am not familiar with that particular case, and you didn't name the company, so.
I don't really want.
Okay, and so if they are recruiting, but the application is online, and they're not, that would have to be, I'd have to go back and ask the staff.
Okay, I'll talk to you after.
Yeah, and certainly, when we're working with companies, if that comes to our attention, then we would advise them what the correct questions are.
Thank you.
Senator Patrick?
Yes, I guess I'm wondering, who monitors online applications? Does anyone monitor online applications? And
Yeah, I think it would be Maine Human Rights or at the federal level, the EEO. And that's an issue of interstate commerce and who has jurisdiction, and that's where it gets a little sticky as we trace it back as to who would be the reporting authority.
Any other questions or comments from the committee? Oh, I guess Mr. Gore has something to share with us.
Just a thought and an offer. My name is Peter Bohr. I'm Vice President of Advocacy at the Maine State Chamber of Commerce. It's just a thought and an offer to the committee. We want to be helpful and promote information that's helpful to businesses and small businesses. We would be glad to, we have a small business microsite that's focused on small businesses. We would be glad to post this pre-employment inquiry on that site. We'll also put it in, I'll make sure that it gets run in Impact in the next few weeks so people have a hard copy of it on both ends, just as a way to get this information out. To be honest with you, until I started, I'm familiar with the Maine Human Rights Act, but until I sat down and did I realize that they had this pre-employment inquiry guide. I think it's very helpful to small businesses because I think the discussion has been, there's going to be a problem, although, and it sounds like in the case that Representative Gilbert points out, it's a larger employer, but most of this comes from small employers. We want to be helpful to make sure that employers don't fall into that trap, and we'd be glad to make sure that this gets printed both online or on our site and in our newsletter. Just an offer.
That'd be great, thank you.
Glad to do it. Thank you.
Representative Gilbert.
Thank you. I want to thank you for that, and I wanted that you could feed that to the newspapers here throughout the state, including the weeklies. They may run something like that.
Yeah, they may. Also, I mean, all of our newsletter material goes to all the local chambers of commerce too, so it can get spread out to those folks as well. And I'll just make sure we do a one-voice conference call every Monday with interested chamber execs. I'll make sure that we discuss it with them at that time as well.
Representative Stracchio?
Thank you, Madam Chair. And specifically for me, that question of, do you know that it's illegal, unlawful to ask someone what year they graduated from high school? I have a feeling that a lot of small business people just don't know that.
No, I think that they've probably used a standard application for many, many years, and they haven't updated it. There it is.
Okay.
Thank you all.
Thank you. I'd be happy to entertain a motion.
Thank you, Senator. I want to thank Mr. Gore for suggesting that the chamber be involved in this. I think that's really helpful. I think that it's great that we had, the bill sponsor brought this forward and we had this discussion, because that in itself is very helpful toward addressing this. So with that being said, I'm going to suggest the motion ought not to pass. And I'm also wondering if the committee has discussed maybe sending a letter to the Department of Labor just to encourage them to work with the Maine Human Rights Commission in ways to help further their message, particularly with such a useful document that we talked about today.
I'll second that.
Seconded by Representative Mastracchio. And I would add that we've got Mr. Clow here from NFIB, and we can get that info out to his members also, because I think it really is the smaller businesses that don't have the human resources professional on staff that, you know, are inadvertently making this mistake and putting themselves in jeopardy, really, because they probably don't have any intention of trying to discriminate, and if they do, they shouldn't be. So we'd appreciate it if you could do the same thing. Thank you. So, any discussion? Senator Patrick.
I'd like to thank Representative LaJoy for bringing this. These are the kind of things that until you hear about it or see one or two things in the paper, you don't really know. It's kind of like a silent thing that happens. You hope it doesn't happen. And if it does happen, both the company and the potential employee loses. So I think what we're doing, although we're not passing the bill, talking about it and getting letters out, and having the chamber and NFIB and thing are good ways to get this out in the open, so more people know about it. So I think it's a real good idea, and thank you, Representative.
Great. Okay. Are we ready for a vote? All those in favor of ought not to pass? It's unanimous, I guess, of those present.
What a united group.
I'm telling you, Representative Campbell. All right, we are doing well. So we will move on. So that ends the work session on LD 673. And Henry, will you be working on the letter?
Yes.
Okay, thank you. And let's open the work session on LD 530, an act to improve public sector collective bargaining laws.
LD 530. This bill amends the municipal public employees labor relations laws by requiring that all collective bargaining negotiation meetings include a member of the body with final authority to approve the collective bargaining agreement. There's a summary testimony there, no analysis. And it includes some excerpts from the municipal public employer employee labor relations law. There's some talk about the purpose of the law. It's declared to be public policy of the state, and its purpose of this chapter to promote the improvement of the relationship between public employers and their employees by providing a uniform basis for recognizing the right of public employees to join labor organizations of their own choosing and be represented by such organizations in collective bargaining for terms and conditions of employment. Employers or employees are required to confer and negotiate in good faith with respect to wages, hours, working conditions, and contract grievance arbitration. And public employers and employees may not interfere with the other party in the selection of the representative for purposes of collective bargaining. And there's no fiscal note required as well.
Henry, did we, is there any information on, would federal law have any jurisdiction in this arena at all?
No,
No? Okay. So
public
we're not,
employees are exempted under the federal law, so it's just a matter of state law.
okay, thank you very much. Senator Patrick.
I'll move like to pass.
I'll second that.
So the motion on the floor is ought to pass by Senator Patrick and seconded by Representative Mastracchio. Any discussion? Senator Patrick.
Thank you very much, Madam Chair. I think this bill is a common sense bill. I think this is a bill that's really not needed as much as one would think, because I think the testimony was that I believe that probably 90% of all negotiations use this as a standard operating procedure already, and for the 10% that don't, I think this will just basically codify it. And I think it's a good idea, and I think it has value.
Representative Mastracchio.
Thank you, Madam Chair. As a school board member for 12 years and a town councilor for 9 years, I participated in negotiations as part of the negotiation team. And we had a team, and it was not an issue of setting up the time that we would negotiate, because that was a mutually agreed upon time. It just seemed to us, as both groups that I belonged to, and there were many people that came in and out, that it just didn't seem right to have someone else negotiate for us, that we owed it to those employees to be at the table, and we owed it to our constituents, the people that elected us. So that was our job. I'm amazed that, I would be surprised to find boards that really don't do that, because I think that Senator Patrick's correct, that most feel that that's one of the most important things that they do. So I'm going to vote in favor of it. I seconded it. I think it's a great bill.
Anyone else wishing to ask questions or speak on this? And I would just add that I agree, it is. I think it's just a matter of whether or not we put it into public policy and force these entities to do what probably is a good idea, but there may be times when, for whatever reason, they have decided not to provide someone at the bargaining table. And I guess that those of us that disagree with the motion probably err on the side of letting them decide on their own. Representative Fecto?
Thank you, Madam Chair. Henry, just to clarify, so school committees and city councils or local municipalities will still have the opportunity to decide who goes to these meetings from their elected officials, and then from their board of elected officials, how many people are assigned to it, so they can set up personnel committees or bargaining committees or whatever it might be. So it doesn't, this bill doesn't restrict local authorities to make decisions regarding who represents the elected officials in these meetings. Is that correct?
It's with the caveat that at least one member of the body with decision-making power would have to be part of the team.
Right. And it doesn't have to be the same member of the body for all those meetings.
I think all the negotiating meetings are.
Because if you set up a personnel committee of 3 elected officials, one could attend one week, another one could attend the next week, for example. This bill does not restrict that from taking place.
I'm sorry, I just want to look at the text again.
It's pretty simple. It doesn't say one way or another. But You're the attorney. Interesting question, Representative Becto. Representative Lockman has something to say.
Yeah, just
Oh,
a
wait.
comment. Wanted to get this in the record. As we all know, the Maine Municipal Association testified against it. Here's what they wrote about it in summary. The most immediate consequences of LD 530 would be to expand the mandatory obligations of municipal officers, making what is already a thankless task even less attractive for aspiring municipal officers, and significantly slow down the process of reaching labor contract agreements because of scheduling difficulties.
Thank you, Representative Lockman. Representative Austin, did you have a question or comment? Representative Mastracchio, and then I think that Henry
Right.
has some information for us.
Right, thank you, Madam Chair, and I'm just going to respond to what Representative Lockman just said. I disagreed with both of those things that MMA said. In fact, we found that prior to us having a policy where we attended, negotiations went on forever because the paid negotiator wasn't really incentivized, I didn't think, to conclude them. And we were able to establish an actual face-to-face relationship with the people that we were negotiating with, and we could, sometimes, people that you're negotiating with just want to be heard. And I think that that is already, as an elected official, one of your primary responsibilities. So it isn't an expansion of duties. I think it is. I always felt in the number of years that I served that that was one of my primary fiduciary responsibilities.
And I don't think anyone is suggesting it's not a good idea to have someone when it's possible, but the question is, do we want to do as a matter of statute? So what is your interpretation, sir?
Okay, so in any collective bargaining negotiating, public employer must include in any collective bargaining negotiation meeting the bargaining agent or representative of that public employer is a member of the body with final authority to approve the collective bargaining agreement. So anytime there is a meeting with the other side, you would have to have that official of the decision-making power.
But does it have to be the same official each time, I think is the question.
No.
Ms. Gay.
No.
Okay, so it could be any member of a town council or a school
Yes.
board, or it could be the town manager perhaps even. All right, are we ready for a vote? Representative Lockman?
Thank you, Madam Chair. Just so it's fresh in everyone's mind before we vote, I want to read another excerpt here. Some municipalities negotiate with up to a dozen different bargaining units, and some negotiations take weeks or even months to resolve. Add to that the fact that many municipal officers and school board members have day jobs during normal business hours, and many evening meetings during the week to accomplish their regular municipal duties. Scheduling a negotiation session under those circumstances would become all the more difficult.
Thank you. Okay, Senator Patrick.
Thank you
I
very
don't
much.
think we're changing anybody's
Chair.
minds.
No, and I don't, and I would say that I was on the school board myself, I was on the negotiating committee, and it takes the amount of time it takes. And when we were done one negotiation, we'd set the date 3, 4, 5 a week later, so you had plenty of time. There was always 3 members of the negotiating committee. Just because that says that in the pamphlet does not necessarily mean it's going to take 1 minute longer. It says there's a possibility of it.
Okay, so the motion on the table is ought to pass. And those in favor of ought to pass on LD 530? And those opposed? And our report would just be ought not to pass. Thank you. There goes our streak. We were doing so well. All right, so that concludes our work session on LD 530. I'd like to move into the work session on LD 612. An act to require a large employer to provide a paper pay stub upon request from an employee.
612. This bill requires an employer with more than 50 employees to provide upon request to an employee a paper receipt of wages at the time the wages are paid. The sponsors proposed an amendment to require that all employers provide a paper receipt of wages unless the employee opts out. Summary of testimony. There was an information request to the Department of Labor. Employees have to ask only once for a printout of their electronic wage statement, but they have to ask every pay period. That included some statutory information for you. 26 MRSA section 665, which is attached. Includes provisions of record-keeping requirements regarding the payment of wages. It's applicable to all employers in the state. There's a section that addresses electronic payments and wage statements are used. So the employer has to
Excuse me,
provide.
Henry.
Yes.
We've got a motion.
Oh, thank you, Senator Perry, not to interrupt you.
Sorry.
I value you very, very much. I think just, I think from looking at this, it seems that this, the problem this bill seeks to address is actually already addressed in current law. So I'm not sure that this legislation is necessary. So I'd like to move ought not to pass.
Second.
So that was seconded by Representative Campbell, right? Okay. Are we ready for a vote or any more discussion? Looks like we're ready for a vote. All those in favor of the ought not to pass on LD 612? Hey, our streak is back. All right. Very good. Okay, so that concludes the work session on LD 612, and now we're going to open the work session on all, or most of the minimum wage bills that have not yet been voted on. So we have LD 36, an act to increase the minimum wage. LD 52, an act to adjust Maine's minimum wage. LD 72, an act to increase the minimum wage. LD 77, an act to raise the minimum wage. LD 92, an act to increase the minimum wage to $8 per hour. LD 487, an act to provide for an increase in the minimum wage. LD 843, an act to raise the minimum wage and index it to the national average wage. And lastly, LD 739, a resolve to establish a working group to evaluate benefits and detriments of increasing the minimum wage. And Henry has compiled a lot of information for us, as has the Department of Labor, and I know they have a lot of information they'd like to go through with us. I don't know if you have some information you'd like to share with us first, and then we'll invite the department to come up.
Sure.
Thank you.
Okay, so got a lot of information here. So for the summary, it says please see attached chart. So this is on page A1. There's a chart. This is the same chart you saw during the public hearing, just kind of organizing the various bills. So there's a column for minimum wage amount, the amount the wage will increase to. Some bills have an automatic adjustment mechanism, so pegging the rate to inflation. And then there are some other things that the bills do, differentiate them. One thing is some of the bills repeal a provision that caps an increase of the, so the state minimum wage is pegged to, if in any year the federal minimum wage increases, the state minimum wage increases as well, but that's capped at $1 an hour. So some of these bills would eliminate that provision, capping the minimum wage increase in that case. One bill, LD 843, also includes a tip credit provision, incrementally phasing out the tip credit by October of 2019. And then LD 739 is resolved to establish a working group to study the benefits and detriments of increasing the minimum wage. If you look on the next page there, A2, there's a chart of the historic minimum wage starting in 1959. If you go across the columns, there's the main minimum wage, federal minimum wage at the same time. And then the main minimum wage and federal minimum wage adjusted for today's dollars. So for example, in 1959, the minimum wage was equivalent to $8.07 an hour today. And it goes through all the subsequent changes over the years. Page A3, next one, that's just sort of a breakdown from the United States Department of Labor website, showing what other states are doing in regards to minimum wage. The next page, A4, is an excerpt from the Department of Labor report in 2011, I believe. So the Department of Labor calculated what the livable wage would be, or an estimate. So there's two charts. The first chart there on A4 is sort of statewide average. And the next chart breaks down what the livable wage would be for various counties in the state.
So, if I'm reading, back up on page A2. So the first minimum wage in Maine was $1, and that was in 1959. And the equivalent is only $8.07 now. That in 2015 dollars, that's what it equates to.
That's what we pulled from some Department of Labor information.
Sorry to interrupt.
So the last page, since we're just going through there, the last page is a veto letter from the chief executive of the last minimum wage bill in the 26th legislature. There's summarized quite a bit of testimony from the public here. There are a number of information requests on page 9.
Somebody has an electronic device that isn't
I'm popping around here pretty quickly, but on page 10, the fourth bullet down, there was discussion of the training wage, also known as the minimum wage. So this is permitted under federal law. It's set at $4.25 an hour currently. For workers under the age of 20, during the first 90 consecutive calendar days of employment with one employer, if their work does not displace other regular minimum wage workers or regular wage workers. So it's not currently permitted under Maine law. There's a potential legal issue, compliance with federal law. The Department of Labor raised with me, I think the U.S. Department of Labor had addressed to them. The maximum tip credit, so we talked about tip credits in the prior bill. The maximum tip credit an employer can claim under federal law is $5.12 an hour. So raising Maine's minimum wage to $10.25 or higher under the current tip credit law, which is you're allowed to claim 50% of the minimum wage. That would exceed the maximum tip credit allowed under the federal regulations. So that's an issue to keep in mind. And there was a proposed amendment at public hearing for minimum wage increase that would not be applicable to younger workers. And the fiscal impact hasn't yet been analyzed.
Wouldn't that be a training wage?
The amendment.
Thank you. At at this point, it seems like it might be a good idea to invite the department to come up and present the information that they've gathered, and appreciate everybody's work on this. Henry, did you have any more, or, I'm sorry, Representative Ward has a question for you.
I was just curious, Henry, I'm looking back on page A2, it's an interesting chart and very insightful, and the column I'm paying attention to is the fourth column from the left. It says main minimum wage in 2015 dollars. Would it be possible to do, or maybe you already have this information, to do a time-weighted average minimum wage that we've experienced since 1959? And what I mean is time-weighted, meaning, for instance, we've carried forward since 2009 the same minimum wage. And I'd be just curious, because it looks as though we started off around $8 an hour, and then factoring in for inflation in the late 60s, it went up for a while above $10 an hour, and then steadily headed down until 1990, where it bought about $6.90 an hour. And since then, it's been generally between $7 and $8 an hour until we upped it in 2009, which in today's dollars would be $8.21 an hour. I'm wondering what the average would be. If you look through that entire period, what would that average minimum wage be in 2015? You see what I'm saying? Yeah. Matter of curiosity, because it varies so much. I just wonder where we're focusing on.
That mic is on down there for some reason, right? Now you should be able to turn your mic on.
Yeah, I think I can definitely try and do that. I think the Department of Labor economist.
Yeah, I think that's probably a better fit for the DOL. Were you listening?
Yeah.
Okay. Sure, come on up, Phil. Welcome.
Thank you.
You're on.
I'm Glenn Mills. I'm an economist at the Center for Workforce Research in the Maine Department of Labor.
Welcome, Mr. Mills. Do you want to go through, did you put together the answer to these questions?
Some of it I gave to Julie.
Or, we've got all sorts of information here. If you want to just go ahead and answer some of these questions.
Okay.
And then I'm sure other questions will come up, unless someone has a question right off the bat that they'd like Mr. Mills to answer. Would you be able to, did you understand what Representative Ward was asking for?
So it's taking these inflation-adjusted wages and calculating an average over time?
Taking the main minimum wage in 2015 dollars.
Yep.
What would the average minimum wage in 1959 be?
In 2015 dollars? Sure, we can do that. That would actually, since these are all in 2015 dollars, that would just simply be a matter of averaging these.
There's a little trick to it because there's a little trick to it because there's a couple of times where there was a gap from 1991 to 96, so you'd have to extrapolate some numbers.
Okay.
All right.
So, yeah, what it would have been in those gap years as well. Okay. Yeah, that'll be a little bit of an exercise we can do.
All right.
All right, so you want me to go through these?
Yeah, I think
questions?
these were sort of requests for information and questions that came up throughout the hearing, so.
Okay. So what is the mean average wage in Maine? So there's a couple, mean and average are the same thing. It's also median. So averages tend to be higher than medians because they're limited on the low side and not constrained on the high side. Or medians tend to be a little lower. It's the middle, laying the lowest value out to the highest value. It's usually a better indicator because means can get skewed by those highs and medians can't. So from the current population survey, the median wage in 2013 was $13.17 an hour for those who are paid hourly wages. That data source doesn't have, that's about 60% of workers. So for the other 40% who are not paid hourly, there isn't an hourly figure. From another program called Occupational Employment Statistics Program, which comes, my office participates in. The median wage is $16.06 an hour. So hourly people, we have assumed a 40-hour work week to them, which is not necessarily correct. Some people work more. But most in that, we collect mostly hourly wages, but for some occupations like teachers, it's an annual and there's an assumption about hours. And the average or mean is a little over $20 an hour from that source. The next question regarding Maine's shrinking workforce will automatically drive up wages. That's not necessarily an absolute, but when labor markets get tight, becomes a competitive environment for workers. So many of you remember the late 1980s when the economy was booming. And the signs on the convenience stores and the fast food restaurants weren't the Whopper deal. It was now hiring $8.50 an hour in 1989 because it was a very competitive environment. We're starting to see those signs again because the labor market is tightening. And we have an awful lot of people leaving the workforce for retirement, a lot of baby boomers, and not many young people coming in. So there is every reason to expect that wages should start to go up. That has always happened everywhere in the country. I shouldn't say always, there's exceptions. When the labor market tightens, wages get bid up, as happens with any product.
Sure.
Is that true for the last 50 years, or has the downward harmonization of the American economy based on the international trade agreements that were signed seem to actually have been lowering job wages